I welcome all the students and today's speaker, Dr. Pratap sir. So I request sir to begin with today's session.
Okay.
Yeah. Thank you, sir.
Okay. Just one moment.
The program which I'm learning right now is the cyber security.
Okay.
Sir, I have made you co-host, so you can
Okay.
present.
Okay. Okay.
Yes.
Good evening to all of you. I hope I am audible and visible. I'm really thankful to Swati ma'am, Madhura ma'am, and all other faculty members of Garwari College for inviting me on this topic, that is Introduction to Intellectual Property Rights. I will request the students, those who are attending this session, to put their mic on off mode. So kindly mute yourself so that it will not disturb the others as well. At the outset, I would like to share one very interesting incident which actually occurred, and that is having a connection with Pune. During Ganesh festival, there was one Ganesh Mandal which had that particular replication of a scene that recreated a scene from novel Harry Potter, on which later on there was a movie which was also made. And in that particular regard, you will find that someone's mic is still on. I will request to mute yourself so that it will not disturb the others. I will just check.
Sir, one more student, Rishikesh, is also a co-host, so
okay,
he'll help you if you require any help.
Okay. So you can mute the other person because that voice that is quite disturbing. Okay, so what happened, that Ganesh Mandal that recreated a scene from novel Harry Potter, on which movie was also made, and that became very interesting thing, and because of which many people, they floated to have a look of the same. And afterward, because more people were visiting to that particular Ganesh Mandal, that became a news item, and that got flashed in the newspaper as well. Somehow, J.K. Rowling, who is the writer of novel Harry Potter, she hired one firm from India for protection of her copyright in all over the world. And as a part of the same, India being a very big country, she hired one firm in India to protect her copyright. Now they came to know that there is one news item which is relating to that particular Harry Potter, and that Harry Potter thing, which is recreated from a novel which is not having any authentication, because there was no such formal permission which was taken either from J.K. Rowling, who is a author of that particular novel, nor there was any such permission which was taken of the publishing house. Now, they send a notice to that Ganesh Mandal that this is a violation of a Copyright Act in India, and this is the hefty amount of fine which you need to pay for violation of my client's copyright. Now, Ganesh Mandal was completely clueless. They were of opinion that all the money which we have invested is our money. We created it. How come that J.K. Rowling, who is the J.K. Rowling, and which is that particular firm, and why they are sending notice to us? Because they were completely clueless that what exactly is the copyright. The hefty amount which was required from that particular Ganesh Mandal, somehow that firm and that particular firm, they came to the settlement, that is out-court settlement, and somehow that was settled, and then they paid a very hefty amount. I'm very sure that whatever contribution which they must have collected from the people, all that particular money must have gone to just pay that particular settlement amount. And they must have learned a lesson relating to the copyright violation. And in their rest of the life, at any point of time, if any scene from Harry Potter, maybe from the movie, if they would have come across or encountered even on their television set or even on their mobile, then also that would have created a concern for them. Because in India, we don't know anything, especially if we are not belonging to the legal fraternity or the intellectual property rights. It is very on a lighter vein, it is said that in India, we don't care about copyright because we are more concerned for right to copy. And we take that right so rampantly, we take that particular right so casually that we don't feel that there is any such need to take a formal permission from that particular person. That is a case. And that's how we come to a point that what is the significance of intellectual property rights in general, and specifically what is the significance of copyright, patent, design, geographical indication, industrial design, and many such legislations. Now there is a quest for a wealth creation amongst the human beings. And this particular quest, which is required to be taken into account, and that is required to be safeguarded. Now there is a tool for this particular wealth creation, which is also undergoing a change, a sea change that we need to understand. Because when humans evolved from the hunter-gatherers to the agriculturists, then land was the first thing which symbolized that particular wealth. And that became a very important tool for their survival as well as for their livelihood. But when technology which progressed, then that particular technology which became the most important tool for that of the wealth creation. And that is really a very important concern, that IPR, which is a legal fencing tool with which the holders of the technology, they maximize their profit. Because when you are having machines at your disposal, when you are having the technology at your disposal, then certainly you can think of that particular profit margin and replicating that particular process or that mechanism. For example, if you want to just manufacture a small pen, then you can replicate this process, you can multiply it, and certainly you can earn huge profit out of it, for which a legal fencing, which is certainly very much required, which is very much justified one. So imagine you have a 5 acres of land, then you can fence it. But if your market is a regional, if it is a national one, or if it is international one, then you need intellectual property right to fence the same thing. And that's why the intellectual property right, which helps you, because 15-acre land to fence it, it is quite tough, but still you can manage. But if entire world is your market, what you are going to fence it? That is a very important concern which you need to understand. Now, the comprehensive approach to the intellectual property right, why it is important one. Suppose you invent a pen. Now, when you invent a pen, then how all the intellectual property rights which come in contact, which became very material one. Because for a pen, you need to register for a patent for the technology by which you create, you manufacture that pen. The design of a pen, which is a unique one, which gives you that particular look, you identify with it, then certainly for industrial design, you need to register yourself. When you manufacture it, you will advertise it, you will go to the customers, you will aggressively market it, then you require, that is the Trademark Act. Because trademark takes care of branding, advertising, reaching out to the people. The copyright, which is for accompanying that particular literature, then that takes care of that particular accompanying literature as well. So you think of a particular pen and all these things will come for your rescue, because you need to safeguard and protect your labor. Labor is not always for doing the manual work. Labor is also of intellectual nature, and that intellectual labor that needs to be safeguarded, that needs to be compensated, that needs to be incentivized. This is very important. And that's why the comprehensive approach, when we look at or we take at the intellectual property rights, then there is a design, that is industrial design, which is required to be adopted for its appearance. So how you look at that particular product, that marketable article, which is something which is really very essential. So that is the design which is there, and it is an appeal to your eye. That is one thing. Second is patent for technology. There are two types of patents. One is process patent. It takes care of the process by which it is created. And second is a product patent. Something new, something unique, out of the world, which you have found. Now that needs to be taken care. So someone else who has not taken pains to create it should not take disadvantage of the situation and should not earn profit out of it. That's why patent is for that particular technology which will take care of the same. The copyright, which is for the accompanying literature, where the copyright which will be for that particular literature, and that will be safeguarded. No copying which will be permitted in that particular regard. And trademark that will take care of its branding. So how branding will take place, that is a lookout of that particular Trademark Act. Now, if we look at the international history of the intellectual property regime, then we find the Greek states were the first to grant the patent for that particular inventions during the 15th century. So we need to take into account that particular thing where the patents which were granted in the 15th century by the Greek state. But until the Industrial Revolution, which we witnessed, the intellectual property right and its significance, that was not a very prominent thing. And it is only after the industrialization, it is only after the industrial resolution or revolution, that particular intellectual property right, which became a very common thing. So the international history of the intellectual property right, if we look at it, then in the 17th century, in 1604, the Statute of Monopolies, more than an attempt to restrict the power of the crown to grant the monopolies, and a genuine desire to protect literary, artistic, sculpture, or the technological work, that will be taken into account. And that was taken into account, and that's how this particular history we can trace back. If we look at 1861, there is a Berne Convention on the protection of that particular copyright. And this particular Berne Convention, which takes care of that particular protection of the intellectual property rights in different areas. In 1882, the Paris Convention on the protection of the industrial property, which also took place. And this Paris Convention, which has also played a significant role for protection of that particular industrial property. Then there is a BIRPI, BIRPI, a private organization for the protection of the intellectual property right in that particular regard. In 1957, there is a birth of WIPO, World Intellectual Property Organization, which became a repository organization for the treaties which were made at the international plane. And in 1994, the WIPO, which became a specialized agency of the United Nations, which took care of all the treaties and the conventions at the international plane for the protection of that the intellectual property right. Now, if we look at the Indian legal regime for the intellectual property right, then we can find the Indian Patents and Design Act 1911, which is no more in existence, which is now repealed, but was the first law which was taking care of the patent and designs. Then there is a Patent Act of 1970, which came into force on 20th April 1972. And this particular act, which also became a thing and which came into force from 1st January 1995. Now, World Trade Organization, which is considered as a super United Nation, unlike the earlier time, the World Trade Organization that proved to be more effective as the international organization, and because of its compulsory dispute settlement powers under WTO, where the absence of adequate intellectual property right protection, which is a type of a subsidy which is given to the domestic business, which all the nations, including the India, they have undertaken to phase out. So World Trade Organization, which took initiative so that there will be uniformity as far as the standards for protection of the intellectual property rights are concerned. Now, the Indian regime, if we see, then the Patent Amendment Act of 2002, which also came into force from 20th May 2003, and the Patent Amendment Act 2005, which also brought certain amendment, which came into force from 1st January 2005, and the Copyright Act of 1956, which came into effect from January 1958. And there is an International Copyright Order of 1999, which also introduced the mechanism by which the intellectual property rights are safeguarded, those are protected. Now, Trade and Mercantile Marks Act 1957, which came into force on 25th November 1949, which is now repealed, and the Trademarks Act of 1999, which became operative in 2003, which is now ruling, and there is a Trademarks Amendment Act of 2010, which introduced few changes into that particular Trademark Act. Now, the Design Act 2000, which also came into force from 1st May 2000, varieties, and the Farmers' Right Act of 2001, which came into force from October 19, which is really very important because the plant varieties which are also protected, and in that there is also a provision for protection of the traditional knowledge, because as a country we need to also safeguard the interest of our own farmers as well. So how these farmers and their traditional knowledge as far as that particular plant varieties are concerned, that can be legalized, that can be recognized within the framework of that particular law. Now, for the trademark, copyright and design, there can be both civil and criminal liability in that particular regard. So, for the patent, the semiconductor chips, the plant varieties, the infringement, in all these things, there can only be the civil liability. And all the intellectual property right infringement cases can only be initiated before the district judge. So at district level, these cases will be entertained, and accordingly, that cognizance which will be taken. Now the interim relief, which will also be given, this is the interim order which is carried out, and that particular order which will take care of that particular phase in which in between that particular order which is required to safeguard the interest of that particular person who is going to be affected if the order is not passed. So normally an interim relief which is granted if two conditions are satisfied. What are those conditions? One is existence of a prima facie case. So in intellectual property right matters, what you need to consider, that is, in intellectual property right matters, prima facie case should be given the due weightage. What is the prima facie case? When you look at that particular case, you need to understand that who is going to have better say, who is going to have better position as far as the contentions are concerned. It means whatever claims which are made, who is in better position to say that this could be the legal position. That is known as a prima facie case. So when you look at it as a first instance, without going at a deeper aspects of that particular case, what is your perception? What is your opinion? That is one. And the second is balance of convenience. Now, balance of convenience, this has to be considered in the light of a doctrine of irreparable harm and relative hardship. Now, this is something which is considered that what do you understand by balance of convenience? Balance of convenience can be understood in a simplistic manner, that who will suffer greater hardship if that order is not passed. For example, if a person is claiming that I am owner of that well, which is used for the irrigation of an agricultural product. Now, if that order is not passed, then in that case, what will occur?
Online
That-
lecture ಇದೆ. Online recorded.
What you need to understand in that particular regard, that if water is not given for the purpose of irrigation, then that agricultural produce will not survive. So to safeguard the interest of that particular person, balance of convenience is in favor of a person who is using that particular water and who is in possession of that particular well. So balance of convenience is in favor of such particular person who will take care, and if that interim order is not passed, then that person will suffer a greater harm. And because that particular greater harm is caused, that particular loss which is caused, that is an irreparable loss which will be caused to that particular person. And that's why in that case, you have to take into account that aspect, that who is going to have that particular greater loss. And accordingly, the balance of convenience which will be considered in that situation. Now, the developments and the contemporary issues, if we take into account, which are associated with the intellectual property rights, then we can find the developments in the biotechnology and the gene mapping which is considered. Now, gene mapping, where this biotechnology or the genetic engineering, where that attempt is made to make certain alterations in gene, to make certain alterations in combinations in DNA, composition in DNA, and accordingly, certain elements, certain illnesses, those can be cured. For example, there is a genetic engineering which is ongoing. For example, if a mother or father is suffering from a cancer, there is a quite considerable possibility that such kind of a cancer will also crept in his or her son or daughter as well. So now, if you are aware that you are suffering from a cancer and you are about to begot a child, then in that case, attempt is made in genetic engineering so that the genetic changes, genetic modifications can be carried out, where that particular multiplication of a cell which will lead to cancer, there you can modify that particular gene and accordingly, you can safeguard that particular person from that illness. So all those hereditary illnesses, like the blood pressure or the cardiac things, those can be taken care by having genetic engineering. Now, whether if this is successful, whether this can be granted a process patent. This is a ethical, moral, legal question which is encountered and which is really very significant and important. Then there is a legal protection of the computer software. This computer software which is really needed, which is really very significant, which is very important one. Then whether the legal protection of that particular computer software which can be there and how that can be achieved. So what is a method to achieve that particular protection? What tools and techniques can be considered? All these aspects will be taken into account. Then there is a public health versus private profit concern. There is a very interesting case, that is a Novartis case. What happened a few years back? Novartis is a company which is manufacturing a life-saving drugs. Especially if a person is suffering from HIV, cancer, or such kind of ailments, then life-saving drugs are required to prolong the lifespan of that person. Now, Novartis, which was manufacturing a drug which was a life-saving drug, that was about to expire. Patent is granted for a period of 20 years. Now, what Novartis did, and which is permitted in all the European nations, that it went for that particular renewal of that patent. That is directly not permitted. Upper limit is for 20 years. But what they did, they changed slightly what can be considered as a cosmetic change in the molecular formula in that drug. And accordingly, they claim that this is a new drug which they have found without having any increase in its effectiveness, without having any modification as far as its outcome is concerned. But it was claimed that this is really a very good drug. Now, in European countries, even the slightest modification will give you new patent. That is known as a evergreening of patent. But Indian way of looking at intellectual property and European or the Western way looking at intellectual property is completely different. In European countries, it is the profiteering which is considered at the focal point. However, in relation with India or Indian subcontinent, it is that particular public health, welfare of public at large, which is considered as the important concern. This is really very significant and important one, that in such case, it is really important that not only those who are having sufficient resources at their disposal, they are having a right to life, but even those who don't have sufficient resources, who are poor, who are unprivileged, who are underprivileged, they are also having a right to life, which is equal right. So this is something which is the important consideration. Now, if we look at the copyright, which protect the literary, artistic, movies, dramas, songs, that is the lyrics and the compositions, books, films, computer software. So wide range which is covered under the copyright. And there is a creation of a knowledge. And this is a primarily protected by that particular copyright system. So it is a requirement, that is the originality. So for copyright, it is really very essential or important that originality should be there. And it should be capable of reduction into a tangible form. I will explain it for you. Reduction into a tangible form means what? For example, there is an idea. You wrote a poem, and it is a collection of a poem which you can print, which you can compile, and you can sell it in the market. So reducing it into a tangible form, which is important aspect. So this is something which is the reduction into that tangible form, which is really very crucial, which is very important. And that copyright which will be granted in that particular regard. So there are different kinds of the rights under the copyright. So right which is to vary according to that particular class of a work in a copyright. So in the case of a literary work, except that particular computer program, the dramatic work, artistic work, musical work, all are considered as having the exclusive right, and accordingly that will be permitted in that particular regard. Here, the different kinds of rights which are permitted under that of the copyright, out of which the first one is right of reproducing the work. How you want to reproduce that particular work. So for example, you will have multiple copies, you will have color copies and sort of things. So you need to reproduce that work. That is first thing. Second is to issue the copies of the work to public at large. So you need to issue the copy of a work to the public at large. For example, you made a movie and you exhibited in 2000 plus cinema halls in this country. So you need to reach out to the people and they will understand that this is something which is of a great significance. Third is to perform the work in public. This is really very crucial or important. So you need to perform that particular work in public, and there is a need to communicate the work to public. So you will communicate that particular work to public at large, and accordingly that particular communication which will happen in that particular regard. Then to make the cinematographic film, sound recording in relation with that particular work, and you need to safeguard it, protect it. Next is to make any translation of a work. Translation is considered or treated as a separate work because there is a creativity which is in that particular regard. So this is something which we have accept in that particular light, in that particular sense. So in a way, to make the adaptation of that particular work, which is also a very important or that particular essential thing. So adaptation, for example, novel is there, like there is a book, Harry Potter, on which a movie is made in that particular regard. Or on Chetan Bhagat's novel, movie Three Idiot is made. Or there is a novel of R.K. Narayan on which movie Guide was made. So this is adaptation. Adapting it from one form to another. That is something which is really very crucial or important fact. So in a copyright, there is the exclusive right, and this is a monopoly right, which is given to make a copy of a film, including the photograph of any image forming that particular part thereof. And accordingly, that particular film, which is including that particular photograph or the image, which is integral part of that particular cinematographic film as well. There is a query which is asked, that is the Gulshan Kumar case from the intellectual property point of view, that how that particular Gulshan Kumar dealt with this particular system. Certainly, I will come to that part as well. In a way, you need to also understand that there are different ways to look at the problem. I will give you a simple example. May it be Gulshan Kumar or a few other persons like Mosabia. It also came up with that particular stand that you go for a particular pirated material. Why you go for it? Because it is available at a cheaper rate. Original movie CD or DVD is for 300, 500 rupee. You get pirated copy at 70, 80, 100 rupee. So instead of paying more, you pay less. But there is a problem that when you go for pirated thing, then you need to compromise your quality. But Mosabia came up with a very interesting module that Mosabia took that copyright in a wholesale manner and accordingly that dealt with that particular situation. There was a mass scale production, and because of which the original CD, which was available at a very cheaper rate, and as more number of copies were selling, because when you are getting original copy at 60 rupee, why you will go for pirated thing? This is also the flip side of the intellectual property rights. I will give you another example that in case of that particular Gulshan Kumar always used to give break to the newcomers, fresh talent in the industry. And he used to engage them, have a contract with them, and used to produce quality kind of albums. And then he used to aggressively market it in the society. And then he used to earn huge profit out of it. So he used to give that decent money to the artist as well. But he adopted a policy that he will always adopt fresh talent. Those who are established or those who are well-to-do, those who are having resources at their disposal, for them, he never acted as a launching pad. Out of musicians pair, Nadeem and Shravan, Nadeem, he wanted to have his album released by Gulshan Kumar. But Gulshan Kumar was not ready because earlier Nadeem's album was released by Gulshan Kumar by T-Series, but that was not of that quality. And because of which Gulshan Kumar was not very happy with the work of a Nadeem out of musicians pair, Nadeem and Shravan. So he was not very much inclined to have that particular second project with Nadeem. But Nadeem, he was pressurizing Gulshan Kumar from Daud Ibrahim and the underworld connections, but Gulshan Kumar never paid a heed for the same. Now, T-Series, which was very well known for a quality product at a very cheaper rate. And that's how those cassettes in those days, the cassettes, it was the prior stage of a CD and DVDs and pen drive. So cassettes, T-Series, that brought such a path-breaking change in the music industry that quality albums at a cheaper rate, because of which a kind of a lobbying which was there in the music industry, because of which the young talent was not coming in the music industry. And that's why it was a coterie which was ruling that particular entire industry. He tried to, in a way, deal with that situation by his own way, by creating a quality product in a subsidized price and launching the newcomers. This was his policy, and out of that particular rivalry over the copyright, over the royalty, few other companies also were behind assassination of Gulshan Kumar, who was a music giant in the film industry. He was assassinated, and accordingly, that assassination took place, and then that was the end of era of that subsidized price and a quality music product. So this was a very good movement in the music industry to bring the fresh talent and to have a particular subsidized price as well. So the cinematography, which deals with to sell or to give or to hire or offer for sell the copy of that particular film. Nowadays, no more video parlors are there or video libraries are there. Before 10, 15 years, in all the cities and in 2-tier, 3-tier cities, video libraries were very popular, and they were earning a huge profit because people were not in a position to purchase those CDs, DVDs, and cassettes of the movies. But at that time, they were able to this particular thing, which was considered, and in that particular sector, you will find that on a rental basis that was available. So to communicate this particular cinematography film to public, that was also considered as one of the important kind of a thing. In the case of a sound recording, the copyright, which is giving the exclusive right to make that particular sound recording and embodying it and selling it or hiring it or offering it for sale or hire and communicating it to the public at large, and accordingly that particular copyright which was dealt. There is something which is called as a performer's right as well. So as a performer has certain right, like right to make a sound recording or a visual recording of that particular performance, or right to produce the sound recording or the visual recording of the performance, and right to broadcast the performance, and right to communicate that particular performance to the public otherwise than by that particular broadcast as well. There is a literary, dramatic, musical, artistic work other than that of the photograph, where the duration of this particular copyright, it is for the period of 60 years from the beginning of the calendar year next following the year in which the author dies. So during the lifetime of the author, copyright is there, and after that author, 60 years, beginning the calendar year next following that particular year, when that particular author will die in that particular situation. So this aspect which we have to consider, where the photography is having a lifespan of 50 years, next year, after the cinematographic work, and the sound recording, it is for the 60 years after its publication, and a performer's right, which subsists for the 25 years. Few years back, there was a controversy between Raja and Yesudas. As all of us are aware that Yesudas is a very well-known singer in South industry as well as in Bollywood. And Raja has also produced masterpieces of melodies, and especially in South industry, Raja is a very popular musician. Now Yesudas, he used to conduct live concerts, and Yesudas took a stand that as a performer, as a singer, I have given the flair to that particular song, and because of which I should get a performer's right. However, Raja took a stand that it is the composer who is composing, and all those compositions, notings which are copyrighted. So it is an intellectual property right, which is in my name as a composer. So you cannot perform it without paying me the royalty, or at least acknowledging the fact that you have taken permission from me. And if I give permission, then only you can perform. Otherwise, you cannot perform, because song is not written by you, and I have composed it. So that composition notings are also of mine, and that's why you have only rendered your voice. So it is my creation. So it is also known as that particular moral right over that particular creation. After movie Three Idiot, when it was a blockbuster hit, but at that time you must have also read about the disagreements between Rajkumar Hirani, director and writer of a movie, and Chetan Bhagat, who also wrote a novel on that particular his life, that is about the college life, and on which the movie Three Idiot, which was based. Now Chetan Bhagat is of opinion that the end in the movie, the way in which it is shown, that was not expected to him. And though I have given you the copyright, but you need to stick to my work. However, Rajkumar Hirani, who is also producer of a movie, is of opinion that, definitely that particular Vidhu Chopra as well, who is the producer of the movie, they took a stand, and Rajkumar Hirani as a director and also the writer, that there are many scenes in the movie because we have paid you, so copyright is with us. Now how we need to modify it, that is our lookout, and we will see to it what artistic liberty which we want to take, what modifications which are required, all those things we will take care, and that aspect is our lookout. So you don't have authority in that regard. However, Chetan Bhagat took a stand that I am the author of that novel, which is adapted in the form of a movie. So I am having a moral right over my creation, despite the fact that I have assigned the copyright in my work. Now, these are few interesting things which we can encounter in our day-to-day situation. So the authorities for the Copyright Act, if we look at it, then there is a registrar of a copyright, which is at New Delhi. Then you will find at other places as well. The next intellectual property is patent, where the application which is made for the creation of a knowledge to produce the useful result. And this is primarily protected by that particular patent. Recently, you must have read about waiving of all intellectual property rights in general and patent in specific. India and South Africa, they appealed to the entire world and especially to the Western countries, that please waive off your intellectual property rights, especially in terms of patent, in the vaccines, ventilators, medicines, injections, which are manufactured, which are invented to deal with COVID-19. Because this is a tough time to which we have encountered. And this is a test whether we give more weightage to the humanity or whether we give more weightage to the profiteering. So you should waive off all the intellectual property rights. Because if that is not done, then vaccination, which is an important tool to combat with that particular disease or the pandemic, we will not be successful in that particular regard. That is what which is considered as a very important thing in that particular situation. So it is considered that in such tough time, that intellectual property right can be waived. Now, patent is having a duration of 20 years, and the registration which is certainly necessary in this particular regard. Now, for a patent, there are different theories which are forming the basis, out of which one important theory is a disclosure theory. But it says it enables the inventor to disclose his invention to the public, and instead of keeping it as a trade secret, it is made known to the authorities like the registrar for the patent, and accordingly that will be granted. So after the expiry of that particular monopoly period, the interested person can use the specification for replicating that particular invention. Now the patent which add the fuel to the fire of a genius Abe Lincoln and the creation of that particular technology, which is highly capital and risk intensive, and the patent monopoly is just rewarded. So the incentive is really very important, because you don't know whatever project which you are funding, it is really going to yield the result, or whether it is not going to yield the result. So it is a very high risk, and that's why this incentivization is really very important. And every invention which improves the quality of a life, so patent also provides a chance to make a commercial success of that particular invention. So patent office is in Mumbai, Kolkata, New Delhi, Chennai. Next is the trademark. Now for trademark, the application which is made for the goods or that particular service, and it is intended to convey to the purchaser that the origin of the good or the assurance of that particular product which is given. Now, trademark is the only intellectual property right which is not having any upper limit. There is only a renewal after 10 years, and after following that process which is required, that will be available for eternity after the regular intervals. Renewal is compulsory. So the public interest concern, which helps the consumer to choose the product, and a commercial certification on the origin of that particular goods or the services, and which also prevent that unjust enrichment in that particular regard as well. So in that particular regard, we have to take into account this very important aspect, that is, it is having a kind of a thing where the consumer would choose a particular product because of that particular thing. And in that particular regard, it is really very essential that you should not in a way facilitate such kind of a deceptive representation, because that is going to give undue advantage to the person who is in that particular situation, used to that a particular situation in such a way, in such a manner, which is not acceptable in any profession. So professional protocols which are also required to be followed. But even if a trademark which is not registered, it's okay. But in that case, the action which is for the passing off. From the name itself, you can make out that you try to pass off your product as if it is the product of someone else. Because you try to act smart and you try to deceive the people who are ready to pay more money for that particular brand, but your quality is not up to the mark. But you just want to have more margin, profit margin, and that's why you try to foul play in that particular regard. So the actual deception, if it is proved, then action for that particular passing off which can be there. So registered trademark, and if it is violated, action can be taken under the Trademark Act. If it is not registered, then certainly in that regard, action can be taken in that particular situation, and accordingly you have to take into account as the action for that of the passing off. The next intellectual property is the industrial design. It is an appeal to the eye. For example, Apple iPhone or Vivo or Redmi. You can easily make out that this is a make of that particular phone. How? Its external appearance. That is the industrial design. It must be novel. It must be published. There must be registration of that particular design. Rights which are conferred for that particular registration. And if it is infringed, then certainly action which can be taken. The passing of action which can also be taken in this particular regard, if it is proved that there was a deceptive similarity in that regard. Next intellectual property right is a geographical indication. Now we say that grapes are from Nashik, apples are from Kashmir, bananas are from Jalgaon, or that slipper, chappal, which is from Kolhapur, Kanjivaram silk or Paithani, or Petha from Agra, Bakarwadi of Pune, Chittale's Bakarwadi. All these are the things which are examples of geographical indication. Geographical conditions, they allow growing this agricultural produce or a particular thing which is manufactured. And that's how you need to take into account the geographical condition, and then you need to advertise that this is the geographical factor which has played a significant role. Even Puneri Pagdi, headgear, which is also having that particular thing. So geographical indication, which is a very important protection. So application which is required to be made, the processing will be by that particular registrar, and advertisement will be as per section 13, and accordingly that protection which will be granted. Now the opposition which will be there, it is a pre-grant opposition before granting of the same. Opposition, if any objection which is required to be taken, it will be taken. Any correction or amendment which is needed, that can also be carried out in that particular regard. Now, no opposition, if it is available to that particular application, then the registration which can be done under that particular section 12. The application content, if you take into account, then there is a name and address, then the geographical indication. If there is any logo or any representable thing is there, that can also be included. The class of a good, that is also there. And the documentary evidence which is in support of that particular legal status of that particular applicant, that bylaw or that particular registration certificate, all those things can also be there. A statement which is containing the list of the members or the producers of the goods, or the certificate in case of the convention application, or the proof of that particular origin and the geographical area which is taking care of that particular same thing, that will be taken into account. Now, the intellectual property office building, which is in Chennai, that takes care of that particular geographical indication. And the last intellectual property right, that is the plant varieties. That is a new variety of existing species. If it discloses a new characteristics which is beneficial, then same can be protected under the Plant Varieties Act. There are certain conditions which are required to be fulfilled, like novelty. It should not be obvious. Non-obviousness should be there. Distinctiveness, that is really very important. Uniformity, which is also equally important one. Stability, which is also a very significant factor. Indian law also protects the right of the farmer to use the seeds of the new variety without any restriction from that particular registered owner in that particular regard. And the period of a protection, which depends on that particular type of that particular plant, and accordingly it can be dealt in that particular situation. So this is all about that particular overview on the intellectual property rights. Like, you cannot pay less to a laborer because there is a provision of minimum wage. On the same line, there is an intellectual labor which is also required to be safeguarded, and you should acknowledge and you should take care of that intellectual labor as well. So we need to acknowledge and we need to respect that intellectual labor. Then we will lead to a society where really there is a respect for the intellectual property rights. With this, I will conclude this session. I'm once again thankful to Swati ma'am and all other faculty members for inviting me and giving me this wonderful opportunity to have interaction with you on intellectual property rights. Thank you very much. If there is no query, then we can conclude this session. Anyone who is taking care of this particular session, they can conclude this particular session. If anyone is having a doubt, yes, you can ask the doubt. Okay, I will share this presentation with you. I will send it to Swati ma'am. You will get this presentation. Okay, if there are no queries, then I think we can conclude the session. Okay. Thank you very much once again.